9 years after the suicide of law student Sushant Rohilla, the Delhi High Court has delivered a landmark judgment that turns one student's tragedy into a blueprint for nationwide reform in higher education. Hello and welcome to another video of The Print. I am Ruchi Bhattar and this video is about how Delhi High Court's judgment transformed the regulatory landscape of higher education, particularly in law colleges, by addressing issues of mental health, grievance redressal mechanisms, and mandatory attendance norms. Sushant Rohilla, a third-year student of Amity Law School, Noida, died by suicide on August 10, 2016, in Delhi's Sarojini Nagar after the college barred him from appearing in his examinations because of attendance shortage. His suicide triggered outrage across the country and drew attention to the pressure and rigidity faced by students in professional institutions. His friend's letter to the Chief Justice of India led to the suo motu petition, which was later transferred to the Delhi High Court in 2017. Over the years, the proceedings evolved from a case about one student's death into what the court called the Sushant Rohilla intervention, a judicial effort to address the wider systematic failures that continue to harm students. Although the criminal investigation under Section 306 of the Indian Penal Code concluded in 2024 with no evidence of abetment of suicide, the High Court chose to keep the matter alive, focusing on the structural issues at the heart of the tragedy. On November 3, 2025, the Delhi High Court issued its final judgment, a sweeping set of directions that will reshape the way universities, especially law schools, handle attendance, student grievances, and mental health. The court noted the alarming rise in student suicides in premier institutions such as IIT Guwahati, NIT Jamshedpur, and NLU Delhi, observing that universities must have the infrastructure to deal with students in distress. It identified two key areas that urgently require reform: grievance redressal mechanisms and the rigid attendance rules that often push students to breaking points. First, on grievance redressal committees, the court examined the University Grants Commission's 2023 regulations, which require all universities to establish such committees. But the High Court found a major flaw. Student representatives were treated as special invitees rather than full members. The bench held that students are best placed to understand the grievances of their peers and that excluding them from decision making undermines the very purpose of these committees. The court therefore directed that all educational institutions must constitute grievance redressal committees in line with the UGC regulations and ordered that at least 50% of the members must be student nominees and that they must serve as full and effective members, not as special invitees. It also mandated that there be representation from all genders and that mental health counselors and therapists be consulted regularly by each committee. Until the UGC formally amends its regulations, every institution must immediately appoint at least 2 to 3 student members to their GRCs. The Bar Council of India was directed to amend its legal education rules of 2008 to require law colleges to include qualified counselors and psychologists in their grievance mechanisms. Second, how did the court address the issue of mandatory attendance? The Bar Council of India defended its rule requiring 70% attendance relaxable to 65% as essential to the professional training of law students. The High Court disagreed and found the rule extremely strict in nature, observing that barring law students from exams solely due to attendance shortage creates serious mental and academic consequences. Citing the National Education Policy 2020, the court noted that the policy makes no mention of mandatory student attendance. Instead, it promotes flexible, multidisciplinary learning that values internships, moot courts, debates, and practical exposure. The court pointed out that attendance finds a mention in the NEP only in the context of evaluating teachers, not students. Accordingly, the High Court directed the Bar Council of India to re-evaluate attendance norms for 3 years and 5 years LLB courses in line with the NEP 2020 and the 2003 UGC regulations. This re-evaluation must include giving credit for co-curricular activities such as moot courts, seminars, debates and court visits, which are integral to the holistic education. The Bar Council was also directed to hold consultations with students, parents and teachers before finalizing any new attendance policy. Meanwhile, to prevent further harm, the court issued binding interim directions with immediate effect. It declared that no student enrolled in any recognized law college, university or institution in India shall be detained from taking examinations or pursuing further academic progress on the ground of insufficient attendance. If a student fails to meet the prescribed attendance percentage, they will still be allowed to take their exams. However, their final result may be penalized by a maximum grade reduction of 5% points or 0.33 in CGPA system. The court further ordered that no law college or university shall impose attendance requirements stricter than those prescribed by the Bar Council of India. All law colleges must also introduce ameliorative measures during the semester itself. These include weekly notifications on attendance, on notice boards or online portals, monthly notices to parents or guardians about shortages, extra physical or online classes for students with low attendance, and assignments or legal aid work to compensate for shortages. In a significant privacy-related direction, the court stayed the Bar Council's circular of September 24, 2024, which had mandated biometric attendance and CCTV surveillance in all law colleges. The High Court called this policy extremely invasive of privacy and rights of students and ordered that it shall not be implemented. The judgment also reminded the Bar Council of its earlier reassurance from 2020 to ensure internships for all law students, especially those from economically weaker backgrounds, remote areas, and among specially able students. Within 3 months, the Bar Council and state bar councils must publish city-wise lists of senior advocates, law firms, and organizations offering internships and keep them updated on their websites. In its closing observations, the High Court noted that the national education policy envisions a holistic learning environment and does not require students to attend the entire course in person to achieve its objectives. With that, thank you for watching.